Erin Payton. I'm the Executive Director of the 19th Century Charitable Association. We are located in Oak Park, Illinois, and our mission is strengthening our community through learning, giving, and sharing our landmark building. We're really happy to have you on this unique program where you're all watching safe and warm at home, and we're glad you were able to tune in today. Before I introduce our program chair, just wanted to let you know, if you haven't been on one of these Zoom programs in a while, there will be a discussion at the end. And if you want to, talk to the presenter, you can put your question or comment in our chat or our Q&A, and I will unmute you so you can pose your question or comment directly to the presenter. Without further ado, let me bring on Judy Eckberg. Judy is the program chair of the Social Sciences programs. Take it away, Judy.
Kate Masur is a professor of history at Northwestern University. She has written widely on the history of race, politics, and law in the 19th century United States. A graduate of Oak Park Public Schools and OPRF, her most recent book is Until Justice Be Done, America's First Civil Rights Movement, From the Revolution to Reconstruction. This talk will highlight the Illinois Black laws that restricted the rights of free African Americans from the state's founding through 1865, and organized efforts to repeal those laws. Among the Illinoisans who demanded repeal were Black leaders Jon Jones and H. Ford Douglass, as well as white editor Zebina Eastman. They and their allies battled Stephen Douglas and other powerful Democrats, and they won some major victories. And now I would like to welcome Kate.
Hi, thank you so much, Judy, and thanks to the 19th Century Charitable Association for inviting me. And as Judy mentioned, I am a native Oak Parker and a graduate of Oak Park River Forest High School, so it's a special pleasure to be here with you today. I only wish that circumstances permitted us to be in person. So as Judy mentioned, today I'm going to be talking about civil rights and Black activism in Antebellum, Illinois. And this was a great oil painting from 1963 that Erin dug up or found online by a Black artist named Alfred Jackson Tyler, remembering Jon Jones and the struggle against the Black laws of Illinois back in the 19th century. So it makes a really nice connection between what I'm going to be talking about today and the things that were on the agenda in the 1960s and indeed are still on many of our agendas today. Okay, so I'm going to be drawing somewhat on my recent book, which came out last spring, Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction. I'm not going to talk explicitly about the book right now, but just so you know that a certain amount of what I'm talking about is in the book, although the book goes much more broadly and is only kind of partially about Illinois. So let me start actually with Jon Jones. In 1864, a Black Chicagoan named Jon Jones published this pamphlet entitled The Black Laws of Illinois and a Few Reasons Why They Should Be Repealed. And in this pamphlet, which was actually published by the Chicago Tribune Company, Jones published the laws themselves, these offensive, racially discriminatory laws of the state of Illinois, and explained, as the title suggests, why they should be repealed. Now, these laws of Illinois, they did some of the following things. They required that Black residents of the state register with local officials, that they post bond for their good behavior to ensure that they wouldn't become paupers or impoverished. They punished any person, Black or white, who sheltered or employed someone who wasn't properly registered with local officials. They barred African Americans from testifying in court cases involving whites. They made the Illinois public schools for white children only. And the state constitution also barred Black men from voting. So in his pamphlet in 1864, Jon Jones addressed the white residents of the state in particular and the state legislators. And among other things, he said to people, to white folks, we know that thousands of you do not know the effect these laws have upon your colored inhabitants. He said, "I know that many friends think the Black laws are a dead letter altogether, but I propose to show before I get through publishing these laws that they are a living, active reality." And so Jones in this pamphlet went on to explain that the law forbidding African Americans from testifying in cases involving white people hurt Black people who were trying to just get a fair hearing in court, but it also hurt the white people with whom they did business. He said that the laws, which with their assumption that African Americans were an outcast group, were illegal, were second-class citizens, to say the least, he said those laws led to segregation and discrimination in schools, in theaters, and other public places. And he said that the laws conveyed to everyone, particularly immigrants, new residents in Illinois, that African Americans had no rights, and this led whites to harass and abuse them. Now, by the time Jon Jones published this pamphlet in November of 1864, he and the movement of which he was part was actually on the cusp of victory in a decades-long struggle for repeal of the Black laws. The Republicans, which was the party most likely to side with their effort, they now controlled the state legislature and the governorship. Jones traveled to Springfield to lobby the legislature in the end of 1864 and into early 1865. And on February 7th, the legislature finally repealed these notorious laws, February 7th, 1865. Now, I kind of started this talk with the end of the story, the repeal of the Illinois Black laws in the winter of 1865, which is also, as you may know, the last year of the Civil War. This is in some ways the end of one phase of Illinois history and the beginning of another. From the earliest days of Illinois statehood and even before statehood, through that moment, this state had explicitly racist laws on the books, laws that were originally designed to discourage African Americans from migrating into the state and to subordinate them once they got here. The repeal of these laws marked the start of a new era in which Illinoisans would confront new kinds of challenges associated with racism and racial inequality. So what I want to do today is illuminate some of that older world, placing the Black laws of Illinois in a broader context and describing the fight against them, and thinking about what lessons we can draw from this history today. So we're going back to the 18th century now and the origins of these laws. Now, the Northwest Ordinance was the federal measure passed in 1787 that created the Northwest Territory. And this is the territory that is now the states of Ohio, Illinois, Indiana, Michigan, and Wisconsin. The Northwest Ordinance declared that slavery was outlawed in this entire territory. And yet, well, first of all, slavery didn't just magically go away. There already was slavery being practiced in this territory, both enslavement of Native Americans dating pretty far back by Europeans and enslavement of people of African descent. And so to the extent that slavery was already being practiced, it was now going to be illegal and phased out. Now, as you can see from the maps on the right-hand side, this big area of land goes through several different kind of subdivisions, which eventually results in the creation of the separate states. And as these territories went from being territories to becoming states, they, even though slavery was on its way out the door, these states adopted laws that were designed to discriminate against free Black people. Now, in Illinois in particular, it has its own interesting kind of story. I'm not going to spend a lot of time on it, but some leading figures in Illinois at the very beginning of statehood actually wanted to proactively legalize slavery itself. They weren't on board with getting rid of it. And so they ended up in Illinois in the early days of statehood, legalizing what were called long-term indentures, which were kind of tantamount to slavery, in which people could be forced to labor as indentured servants for periods, extremely long periods, not just for 5 years or something like that, but for up to 99 years or a lifetime. And these kind of indentured servitude contracts were only given to African Americans. So in other words, white people were not forced into these kind of contracts. And usually what would happen would be enslavers migrating from slave states into Illinois would convert their kind of holding of a person as property into one of these long-term indentures, which really wasn't very different from slavery itself. However, the number of people held in bondage in Illinois was very small. And through activism and court cases over time, this amount of slavery was kind of eroded. So by 1845, the state Supreme Court declared that it was illegal to treat people as property in the state. Okay, so, but at the same time, as slavery itself was going by the wayside, the state repeatedly doubled down on these laws that were explicitly about discriminating against free African Americans. Now, Indiana, Illinois, and Ohio all had laws like this. And these are the states of the Old Northwest that border on the Ohio River and the slave states. And so legislators in these states, more so than in Wisconsin and Michigan, were concerned about Black migration into the states. And that is the reason why they, more than Wisconsin and Michigan, had laws like this. So these Black laws in the states were designed to discourage Black migration by making life difficult for African Americans who moved here. They were designed to marginalize and subordinate people once they got here. And some of the nuts and bolts of things that these laws provided for, or the laws did, as I mentioned earlier, they placed restrictions on Black people's ability to legally settle in a county. That is to say, to become like a legal resident of a given jurisdiction. They required Black residents to register with county officials, and to register, they would have to pay a fee to register. They might have to post a bond, which would be like a promise of in some cases, like in Illinois, up to $1,000, that they would not become a public charge. And to register, by the way, you had to bring free papers. So part of what the government was trying to do here was stop people from deciding to come in as fugitive slaves, as runaways from slavery. So in order to be able to register, you had to bring your free papers showing that you were a free person of color to a county clerk and then be registered in the book. These laws placed penalties on employers who employed people who didn't have proper papers. These laws prohibited African Americans from testifying in court cases involving white people, as I mentioned. Eventually, as these states created public school systems, the state laws provided that schools were for white children only, not for Black children. And then the constitutions of these states, not statutes, but the constitutions, provided that voting was for white men only. So these are the kind of panoply of policies that these states, including Illinois, had at the time. Now, you might wonder, and I'm a person who thinks a lot about law and things like the Constitution. So you might wonder, how could you even have laws like this? Were these laws actually constitutional? Could you challenge these laws? How is this even possible? Well, the short version of the story is, in the years after the American Revolution and before the Civil War and Reconstruction, there were actually very few limits on states' power to infringe on what we think of as the rights of individuals. And this was a profoundly unequal and hierarchical society. So state governments could decide who was a citizen of the state. They could decide whether women would be permitted to keep property that they owned after they were married. They could decide whether to have slavery or not to have slavery. They could decide whether to prohibit people from voting based on their race, their gender, their age, or their wealth. And states could decide whether to make people who they considered paupers or vagrants deportable from the state. And in this context, they also could decide whether to restrict the basic civil rights of free people based on race. And almost no one in the United States, especially at the beginning of the United States, almost no one from the period from the American Revolution to the Civil War believed that these laws violated the US Constitution. Now, some people might think, well, what about the Bill of Rights? Doesn't that enumerate certain basic rights that all people were entitled to? The answer is no. From the beginning of the nation until the Civil War, it was understood that the Bill of Rights protected people's rights only against the federal government, not against the states. So again, state governments had wide latitude to abridge people's rights, essentially. One of the ways that they did this and justified this, and this will be familiar to us in some ways, is through what were called the police powers of the states. This was not police in the sense of uniformed police with blue uniforms. The police powers were the set of powers that state governments and local governments had to regulate people and businesses in the name of the public good. So states and municipalities regularly use their police powers to create fire codes or regulate slaughterhouses, like all of the things that a state or local government can do in the name of protecting the public health, the public peace, the public good. These fall under the kind of rubric of police powers of the states. And so the whole conversation that we have been having about mask mandates and the relationship between masks or vaccines and individual rights, these are also a question of police powers of the states and local government, in the sense that you're balancing what is in the collective public good versus what people think are their individual rights. And within the police powers of the states in this period were the poor laws, and these allowed for and this came from a tradition from going all the way back to England and before the American Revolution, which allowed for the regulation and even expulsion of the poor, particularly those who were newcomers to the community. So again, in the name of public good, if you had newcomers who were poor in your community who seemed to be dependent, it was considered entirely legitimate to throw them out of the community and deport them back to the place where they were originally from. So why am I describing this? First of all, I'm describing this as a way of understanding the broad range of powers that state and local governments had, including powers to discriminate based on race, and how these powers were justified. So the Black laws of the Midwest, including in Illinois, they were built on and intertwined with the poor laws, in fact. So the enforcers of these registration laws that applied only to African Americans, they were the overseers of the poor. And the idea that a certain class of people had to come, when they came into a jurisdiction, had to register and show their papers, that was an idea that was translated from the history of English poor laws into the racial context of the early United States and Illinois in particular. And so what they were basically saying was, in order to protect the public peace and the public welfare, this is what the legislature was saying, we need to have Black residents register with local officials. It's in the name of the public good. So these laws, these Black laws, enjoyed a lot of legitimacy, and states north of the Ohio River, including Illinois, passed laws like these and repassed them and updated them, often in response to policies in the adjacent slave states, which in the early 19th century were placing growing restrictions on free Black residents. So like Kentucky or Missouri would pass new laws that made life more difficult for free Black people in those states. And then Illinois, Indiana, and Ohio would respond with more stringent laws of their own. Legislators in Illinois regularly argued that free African Americans were an undesirable population, much like paupers and vagrants, that they would become dependent on public resources and a threat to the public peace. And so they argued that their states needed to take steps like these laws to discourage migration by adopting policies that subjected African Americans to unpleasant and expensive legal processes, and also rendered them vulnerable to popular violence, right? Because when you send the message that somebody or some group of people are not protected by the law, that opens the door to people who are interested in breaking the law to abuse them. So one of my questions has been, how did people fight back against these laws? And in Illinois and other states, in the northern states, African Americans were only a tiny fraction of the population, and Black men were not permitted to vote. Many whites accepted the laws or thought they were none of their concern. And so how do you mobilize support for repeal of these laws? They're not unconstitutional. You can't turn to the federal government for help. African Americans are a tiny minority in Illinois, and most white people are not opposed to these kind of laws. So in my book, I talk about this movement that kind of gathers steam over time to repeal laws like the ones in Illinois, Indiana, and Ohio. And here I'm gonna talk more about Illinois. Now, the movement against these racist laws gained new footing in the 1830s with the rise of radical abolitionism. So people have probably heard of the abolitionists. You might have the person who might come to mind is William Lloyd Garrison from Massachusetts. I think people actually know a lot more about abolitionists on the East Coast than they do about the movement in the Midwest. And one of the great things for me about studying this has been learning about how all of this unfolded in places like Illinois. It's well known, obviously, that abolitionists were opposed to slavery. They were struggling against slavery. But what a lot of people don't know is that they also turned their attention to their home states and tried to make more racially just, racially equal policies at home. Now, early white settlement of Illinois started from the south and along the Mississippi River. And I really like this Illinois map from 1820, right after Illinois became a state, because it shows where white settlers had kind of already mapped where white settlement was going to go. And it's counterintuitive if you're from Chicago to understand that Chicago was a kind of a late development in this process. And there's really not much there in terms of white settlement in 1820. The area of the map that you see that's kind of not platted out here in counties and rectangles was considered to be land over which Native people had sovereignty and jurisdiction at that point in 1820. In the early 1830s, there were a series of treaties between the United States government and the Chippewa, Ottawa, Potawatomi, Ho-Chunk, and Menominee tribes, in which those tribes ceded land on the western shore of Lake Michigan to the United States. After that, white settlement of northern Illinois happened very quickly, with migration streams coming across the northern parts of the United States. So instead of people migrating in from the southern United States, from places like Kentucky, now people were migrating in from places like Ohio and further east. And these migration streams began to change the tenor of politics in the state. Chicago and far northern Illinois became centers for abolitionism, and significant Black leadership emerged after about the mid-1840s. Now, in the 1830s, small anti-slavery societies formed in communities throughout the state. And some of these rural communities, not only in northern Illinois, but in southern and central Illinois, were settled by white people who shared anti-slavery views and made communities based on that kind of anti-slavery conviction. But the presence of abolitionism in Illinois was highly contested. The 1830s were a period of a lot of anti-abolitionist violence. And the murder of Elijah Lovejoy, an anti-slavery minister and editor in Alton, Illinois in 1837, became nationally notorious and was a symbol of just how much violence both white and Black anti-slavery activists faced in many places, not just in Illinois. But after Lovejoy's murder, instead of backing out of Illinois, some abolitionists wanted to pursue a presence in Illinois even more strongly. And so in 1838, the veteran anti-slavery editor Benjamin Lundy moved to Illinois to publish a newspaper. And then in 1839, Zebina Eastman, an editor from Massachusetts, came out to help Lundy with this new paper. Now, Lundy soon passed away, and Eastman carried on the effort. And Eastman became one of the most important figures, I think, in pressing for repeal of the Illinois Black Law using the paper that he edited called The Western Citizen. Now, just to give you a sense of a couple more developments, or one more development in Illinois, in 1840, the Will County Anti-Slavery Society was trying to do what Jon Jones would do more than 2 decades later in an effort to alert white people to the damaging nature of the Black laws of Illinois. The Will County Anti-Slavery Society published a pamphlet called The Slave Code of Illinois, and you can see the cover of that on the left. And it's interesting because this is from, this document is in the collection of the Chicago History Museum, and you can see in script right here, it's presented by Zebina Eastman in Chicago. So this was Eastman's own copy of this pamphlet. And so the pamphlet publishes the Black laws of Illinois and tries to get people to notice that these are really terrible, racist, unfair laws that shouldn't be on the books. They're not going to get very far right away. In 1842, Chicago abolitionists invited Zebina Eastman to come to Chicago and publish his paper, The Western Citizen. And one of the things that Eastman did then was, with his printing press in Chicago, published more copies of the Slave Code of the state of Illinois, this document that the Will County Anti-Slavery Society had published. Now, what else did people who wanted to see repeal of the Illinois Black Laws do? What was their strategy? One of the things they did, and we see this across the Midwestern states in these efforts to repeal these Black laws, they petitioned the state legislature. So the newspaper editors like Eastman could publish in their paper a petition form like this one that you see here on the right-hand side. It's very brief, and it says, "To the Senate and House of Representatives of the state of Illinois, the undersigned citizens of Illinois respectfully pray your honorable body to pass a law granting a trial by jury to all persons where liberty is at stake." And that is speaking to the issue of fugitive slaves who were not entitled to a jury trial. To repeal the law which justifies the imprisonment of persons without charge, and to repeal all other laws which operate to oppress our fellow men on account of color. So they're asking for all of the Black laws to be repealed. Now, this was a very practical kind of document. It's a very small document that would be published in a newspaper, just like one little square in a newspaper. And then the expectation was that people would cut it out with scissors and paste it to a piece of paper, and then take it around and get signatories on the petition, and then send it into the state legislature. So Eastman and the Western Citizen newspaper published petitions like this and invited people to cut them out, sign them, send them in, let the state legislature know that people really care about this issue. And petitioning is really interesting in the 19th century because, and now anybody can petition. So back then, as now, women could petition, African Americans could petition. You did not have to be a voter to be able to petition. And legislatures and legislative bodies had to take your petition seriously. They had to take it under consideration. And so what you see is these petitions coming into the Illinois legislature. For the most part, the legislature sends them to a committee and then publishes an explanation of why they're refusing to repeal the laws. And what purpose this served for the activists was to make the argument and display that many people care about this issue, to make a moral argument that just because a majority of voters support this doesn't mean that it's right. And also, once the legislature would generate these reports saying, here are all of the reasons why we're keeping these noxious laws, then the press would report on the reports themselves. So they're essentially publicizing the issue and trying to get people to understand just how damaging these laws are. Another thing that Eastman and his allies did in Chicago was to try to humiliate and denounce anyone who tried to enforce the Black laws. And there's an example of this from 1842, right after the newspaper had moved to Chicago, that is so interesting to me. In the fall of 1842, the Western Citizen covered an attempt to enforce this part of the state law that required all Black or mulatto people to carry freedom certificates and register with local officials, as I described. And on your left is an example of this is actually a freedom certificate that somebody carried with them. This I found in the Ohio Historical Society in Columbus, Ohio. So it's not from Illinois, but people had to carry, African Americans had to carry a folded up certificate in their pocket to show their freedom. And this is what they would take to register with local officials. And this is like a form of an identity paper. Again, not something that a white person would ever have to carry. So a conflict arose when a Black man named Edwin Heathcock got into an argument with a white man while they were both working on a farm on the outskirts of Chicago, but in Cook County. The white man assaulted Heathcock, and then, worried that he was going to get into trouble, the white guy, he went and reported to authorities that Heathcock was in the state illegally with no free papers. The Cook County sheriff then arrested Heathcock, who didn't have his free papers with him, as it turned out. Now, when the Western Citizen found out about this, the paper railed against the arrest of Heathcock, saying it was an example of, quote, the enormity and palpable injustice of the Illinois Black law. Oop, too soon for that. After Heathcock's arrest, in keeping with state law, the sheriff of Cook County, and this is the first Cook County courthouse in Chicago, this picture right here, the sheriff came in front of the courthouse in front of a crowd of people and demanded, according to law, that someone had to bid to hire out Heathcock to labor for up to 1 year. And this is because what the state law said was, if you were a Black person who was arrested and didn't have your papers with you and you couldn't prove that you were free, you would be kind of auctioned off to labor, and someone would bid on you to get, and you would then go work for that bidder for up to a year. And so, and the person who bid on you for your labor did not have to pay you. So you're basically becoming a slave, not for life, but for a period of time until you can either prove your freedom, or after a year had elapsed, you would then become eligible for free paper. So you have to work for no pay for a full year, and then you're eligible for free papers. Okay, so the sheriff comes out, the Cook County sheriff, and says, who is going to bid on Edward Heathcock? And nobody volunteers. Nobody is willing to participate in this kind of legal proceeding. And finally, the sheriff says, if nobody bids, I'm going to have to take him back to jail, and he's going to have to stay in jail. And so finally, a prominent resident of Chicago comes forward and says, I'll bid 25 cents. Which was kind of a token gesture, right? Like not really bidding any kind of real money, but just saying, I'll pay 25 cents to have him be released. And from that point on, Heathcock was a free man. Now, once again, the Western Citizen newspaper covered this event. It covered this kind of sham of a fake auction of Heathcock. And it said, the Western Citizen newspaper reported that the crowd was in a state of, quote, disgust and indignation that this entire thing was happening in Chicago. Now, one of the things that I found so interesting when I continued to research this was that I ended up finding a document. It was a newspaper story in which Eastman, in 1874, so many decades later, recounted some of the backstory to this. So we know from the time period that there was a hostile crowd who didn't approve of the enforcement of this law, who thought that Heathcock should be free. So Eastman in 1874, many years later, recounts that what had happened was that he and his allies had manufactured that crowd. The day before the auction, they had gone around in the middle of the night posting broadsides all over, especially near churches. And this was on a Saturday night going into Sunday morning, encouraging people to come out and show their disapproval of these proceedings the next day. On the broadside, it said, the solid men of Chicago are requested to be present and witness the first man sale in our county. And so part of the reason why the sheriff faced this crowd of people who refused to participate in enforcing the law was because Eastman and his friends had drummed up a crowd that they knew would be hostile and would refuse to participate. And so this example shows just another way that the people involved in trying to get the laws repealed and show how unjust they were, tried to shape public opinion. And they tried to make Chicago a place where these laws could not be enforced. And as far as we can tell, for the most part, after this, these registration laws were not enforced in the city of Chicago, and Chicago became an increasingly safe place for free African Americans to live. So around this time, the city's Black population began to grow more steadily as Black residents began to settle in the city. And it wasn't only, to be sure, the lack of enforcement of the Black laws really mattered, but the city was also growing expansively in this time period. And so there were a lot of economic opportunities for African Americans. And these folks became increasingly organized and increasingly vocal about repealing the Black laws. So here I have pictures of Jon Jones, his wife, Mary Richardson Jones, and Henry O. Wagner. All of them are very well documented, very interesting people. Many of the Black residents of Illinois and of Chicago were migrants from the slave states. Some had been born enslaved, some had been born free. Jon Jones, for example, was born free in North Carolina in 1816. His mother, who was a free Black woman, apprenticed him out to a tailor so that he would learn the trade of tailoring. He got taken as an apprentice to Memphis, where he met Mary Richardson, who was also from a free Black family from Tennessee. Richardson's family moved to Alton, Illinois. Jon Jones moved to Alton after that. He and Mary got married. And then the pair moved to Chicago in 1845 with their baby daughter, Lavinia. Jones was largely self-educated and he became a leading activist, and he's the person I started to talk with. In 1847 is the first time we see him in writing as a constitutional convention met in Springfield to create a new state constitution. Jones published a series of articles in the brand new Chicago Tribune, arguing that the new constitution should repeal the Black laws and also give Black men the right to vote. He became very active in the nationwide Black convention movement, or it was active across the North. And then he and Mary at home, they opened their doors to fugitive slaves. They were active as on the kind of Underground Railroad. They helped people who were moving through Chicago, escaping slavery, many of them moving to Canada. Just as a quick, Henry Wagner, he was born in Maryland, eventually moved to Galena, Illinois in 1839, where he learned the printing trade. Then he moved to Canada for a while, where he met his wife, Susan Lyons. And in 1846, they moved to Chicago, where Wagner at first worked for Zebina Eastman on the Western Citizen before Wagner with his wife, started their own catering and produce business. And these people and many other Black Chicagoans were leaders in the fight to repeal the Black laws of Illinois. Now, what their prospects were in the 1840s and early 1850s was very unclear. This was a really volatile time in American politics. And to give you an example of a state that went a different direction, in 1849, due to pressure from Black and white activists in Ohio, the state of Ohio actually repealed most of its Black laws in 1849. So there were reasons to think that a movement like this could be successful. But in Illinois, things really went the opposite direction. And so in 1853, John Logan, who you may have heard of as a Civil War general and the founder of Memorial Day, and he later became a Republican, but in the 1850s in Illinois, he was a Democrat. Logan introduced a measure that would actually attempt to completely ban new Black migration into the state. The measure said that any African-American person coming into the state for more than 10 days could be arrested. And if they were convicted of violating the law, they could be sold to the highest bidder to pay off the cost of court and jail fees. Now, again, this was not selling someone into lifelong slavery, but the attempt to ban Black migration into Illinois was extremely radical in the negative sense for the time. It was extremely reactionary. And so anti-slavery editors like Eastman called it the Illinois slave law. And they used this law, which was damaging, was dangerous to African-Americans. The activist people used this to publicize just how far their opponents were willing to go. And this new 1853 slave law of Illinois got attention all over the North as being a symptom of just kind of the worst forces in Northern politics. The 1850s were a really difficult time for free African Americans in the North. The US Congress passed the Federal Fugitive Slave Act in 1850, which made Black Northerners vulnerable to kidnapping and being dragged back into slavery. And Indiana actually preceded Illinois in passing a law actually through their state constitution that tried to ban Black migration. So by 1853, both Indiana and Illinois had tried to do this. And some leading Black activists, including this person here, Martin Delaney, were at this point arguing that African Americans had no real future in the United States and that they should move, they should emigrate out of the United States, maybe to Canada, maybe to Haiti, maybe possibly to West Africa. And so the idea here coming out of a sense of pessimism was, look, this country's never going to change and we need to figure out another route. We need to move, we need to get out of here. Other people, though, other prominent Black activists, including Frederick Douglass, for example, fought to stay in the United States. And this was the context in which Black residents of Illinois held their first statewide political convention. And I'm going to kind of depart a little bit from my main part of my talk, or I mean, this is related, but what you see here, this image is a screenshot of a website that I've been working on with a team of students and staff at Northwestern for the last almost 2 years now. This website isn't published yet, but it's going to be published during February. Certainly by the end of February, it will be open and available to the public. And what we did here was a lot of research and kind of pulling together of the history of African Americans in Illinois in the 1840s and 50s, which culminates in this Black political convention that met in Chicago in 1853, whose main agenda item was calling for repeal of the Illinois Black laws. And so these were the folks who disagreed with Martin Delany that we should leave this country and argued that we should stay here and fight for citizenship and full equality. And just to give you a sense of the website, we have a whole lot of different things going on. You'll go to these drop-down menus. But on the convention that met in Chicago in 1853, we have a part that describes how the convention came about. They were fighting back against this new law that John Logan had overseen to get through the legislature. Then what happened at the convention itself. Frederick Douglass was the headline speaker at the convention. And then how Black Illinoisans mobilized after the convention to kind of continue this work. Now, so again, this is forthcoming from the website. Also, I'm really excited that we wrote biographical profiles of 25 individual people, men and women. And so you can read the stories of people like Jon Jones and Henry Wagner and Mary Jones, but also a variety of people who were not nearly as well known as they were. So what could Black residents of Illinois expect from the Illinois legislature in the 1850s? It was a very uphill battle. So they were determined to keep fighting, but with Democrats in charge of the state legislature, there wasn't a lot of hope of getting things done. And things were going to have to shift politically in order to accomplish repeal of the Black laws. So I'm going to kind of fast forward over a fair amount of history now. What did shift significantly was the dissolution of the main party configuration that it had kind of been in place in the United States since the 1830s. It used to be the Whigs and the Democrats. The Whig party kind of disappeared. A lot of Illinois Democrats got very tired of the Democratic Party and Stephen Douglas in particular. And so a new party forms, the Republican Party. And the Republican Party picks up the fight against racially discriminatory laws, this fight that's been going on at the state level in many states, including Illinois, for many decades. And so you have here some very well-known Republicans and their state that they're identified with. All of these men and many other well-known Republicans were on record in the pre-Civil War years fighting against racist policies in the North. And they become Republicans who then come into power in the 1860s and have the ability to shape federal policy. Now, I said that these folks were all on record in support of things like repeal of the Black laws. One person who was not on record supporting repeal of the Illinois Black laws was Abraham Lincoln. So to the frustration of many of the activists that I'm writing about, Lincoln apparently wouldn't go on record calling for repeal of the Black laws. There's not a lot of documentation one way or another, but there's certainly no evidence that he ever did call for repeal of the Black laws. And there's some evidence that people approached him about doing so and he refused. That being said, Lincoln had very different views from Stephen Douglas, the leading Democrat in Illinois, about the rights of free African Americans. And so Douglas, for example, had argued that, had defended the Illinois Black laws as the United States Senator. In the Lincoln-Douglas debates, Douglas maintained the position, and I quote here, "The United States was made by the white man for the benefit of the white man, to be administered by white men in such manner as they should determine." And he also argued that the Declaration of Independence had been intended for white people only. And he said, quote, "I am opposed to Negro citizenship in any and every form." Lincoln was really opposite of Douglas on these policies. So although he didn't call for repeal of the Black laws, Lincoln emphasized that the Declaration of Independence, the idea that all people were created equal and entitled to life, liberty, and the pursuit of happiness, Lincoln believed that those promises were promises to which all people were entitled, not just white people. And after he became president, Lincoln's administration not only supported the abolition of slavery, but also where they believed they had constitutional power, supported the principle of African-American citizenship and racial equality before the law. With the Republicans in charge in the 1860s, that vision of that racially discriminatory laws are should be unconstitutional, should not be permitted, that vision finally made it into the halls of federal power. In the first half of 1866, Congress passed both the nation's first federal civil rights measure, which is called the Civil Rights Act of 1866, and the 14th Amendment, which promises to all people equal protection and due process of the law. And the 15th Amendment passed shortly thereafter, barred racial discrimination in the right to vote. And so these constitutional amendments changed the Constitution from what I described before, being a Constitution that didn't put any restraints on the states in terms of how they could discriminate. And now, because we have these amendments, the states are restrained from having laws like the laws that we had in Illinois up until 1865. Now, thanks to Jon Jones and other Black activists, along with their white allies, Illinois got in under the wire. So repealing the Black laws in the winter of 1865, about 1 year before the Civil Rights Act of 1866 would have made those laws a violation of federal law. But the Illinois government actually did not go forward with enfranchising African-American men, and Black men only got the right to vote in Illinois because the 15th Amendment forced Illinois to do that. Now, we know that the federal measures of Reconstruction did not solve the problems of racial inequality and personal prejudice in the United States. And the amendments went unenforced for almost a century. Right, from the 1870s until the 1960s, these amendments were completely unenforced, undermined by the Supreme Court and by white supremacy. But these amendments were also the constitutional foundation for the new civil rights measures of the 1960s that finally allowed the United States to begin to deliver on promises of greater equality and dignity for all people. And I want to conclude with Martin Luther King, who I ended my book with, as a matter of fact, and it's the Martin Luther King holiday today. While I was writing the book, I kept thinking about a quote from Martin Luther King from the period right before Congress passed the 1964 Civil Rights Act. And I ended my book with this quote, actually. So critics would say to King, "You're a minister. You should be concerned with people's spiritual well-being. You can't legislate morality," they would say. You have to change people's hearts and souls first. And King's response was this, and he said versions of this many times: "It may be true that morality cannot be legislated, but behavior can be regulated. It may be true that the law cannot make a man love me, but it can keep him from lynching me. It may be true that the law cannot change the heart, but it can restrain the heartless. This is what we often do and we have to do in society through legislation." He's really making the case that changing the law matters. And in other places, he made the case that people's own personal prejudices would dissipate as laws changed and leaders made the effort to show that they stood for, and the government stands for, principles of equality. So right now, as we face a critical need for federal legislation to protect the right to vote under the 15th Amendment, while our democracy is at stake, once again, I think we would do well to think not only of Martin Luther King, but of the long ago movement whose steadfast efforts to organize, change public opinion, and build coalitions gave us the constitutional scaffolding for strengthening our democracy today. Thank you very much for your attention, and I would love to take questions and hear your thoughts.
Hello, welcome back to me.
Hi.
Great presentation. Like I said before, if you have any questions or comments, you can please type them in a chat. Oh, here's a Q&A right away. All right, Agatha has a great question. So Agatha, I am going to ask you to unmute.
Got it.
Hi, go ahead and ask your
Hi
question.
there, Erin. I had a question, and I don't know if you see this, Dr. Masur, but is it that what the Democrats and the Republicans stood for back in the 1800s different than what they stand for now? And that's somewhat confusing, isn't it? Because you just mentioned these three people, which I don't remember their names, but who wanted to, remove these black laws, and they were all white, I think. White, they looked upper class. So, is that a little confusing, or is that just in my mind a bit confusing?
Well, it's a story of American history that I think a lot of people have questions about. So the answer is, first of all, yes. So the Republican Party of the Civil War period, or the period I'm talking about, it was founded in the mid 1850s. And if you think about it, I mean, Abraham Lincoln was the first Republican president. And the Republican Party got off the ground in part in opposition to the spread of slavery. It was a far more anti-slavery and pro-racial equality political party, at least in terms of mainstream parties, than the United States had ever seen before. And it was the Republicans of this period who wanted to pass those Reconstruction amendments, who wanted to have Black men have the right to vote, who wanted enforcement of, to make sure that people's civil rights were enforced. And so that was the Republican Party of that time. And then the Democratic Party of this time, and Stephen Douglas was a leading Democrat, the guy who said this is a white man's country and so on. The Democratic Party of that time was the party that was much more likely to be aligned with white supremacy. Many members of the Ku Klux Klan in the aftermath of the Civil War were Democrats. And so here's the thing. Through the course of American history from that period until the present, and what the parties have stood for has changed quite a lot. And particularly in the 1930s to the 1960s, this transformation happened. And it's a longer kind of story than I can get into now, but more and more, it used to be that all Southern white people, there were virtually no Southern white people who voted Republican, because the Republicans were the party that crushed them during the Civil War and abolished slavery. So almost all Southern white folks were Democrats. Almost all African Americans voted Republican. That began to change roughly in the 1930s. African Americans, particularly who had migrated to the North and were able to vote, tended to increasingly vote for the Democratic Party because they supported the New Deal and they supported things that Franklin Roosevelt did. Meanwhile, especially after the 40s and 50s, as the Democrats increasingly came to support federal civil rights measures, growing numbers of white Southerners stopped being Democrats and turned to the Republican Party as a party that didn't stand for either civil rights for African Americans or union rights. And so there has been this change, and oftentimes people will ask me about it. And I think it's really important to talk about it and understand it. And so I'm always happy to talk about it and kind of and answer questions about it.
It almost sounds like it could be its own program.
Yeah, for sure.
Yeah. Margaret Burke has a question that I don't think that she needs to ask, but how are you going to let us know about your website when it's up?
Well, I can't wait for the website to be published, and I'm going to let Erin know about it, and then hopefully she can publicize it to you all. And I am so excited about it. It's been a lot of work, and and once people start interacting with it, I hope it will be interesting to you, and maybe also spur additional research, because there's just so much to find out. And particularly doing those profiles of individuals, we use census data, we used a lot of kind of digitized sources, ancestry, like the kinds of research that genealogists use. And we were able to learn a lot about people and their very interesting lives.
Oh, it just sounds so fascinating.
Yeah.
Carolyn Skipper has her hand raised, so I'm going to take a chance. Carolyn, did you have a question? I asked you to unmute. Hi.
It's not me. Ralph Lee is with me, and he has.
Hi, Ralph.
My question is this: will a recording of this entire presentation be accessible to people who are not able to be here right now?
Yes, we are recording this program right now. And my darling husband will edit it when he can, and it will go up on the 19th Century website. how long it will be up is to be determined between Kate and I, but it won't be up forever. So when it does come up, you send it out to your friends if they missed it. And hopefully the timing of it works out great and the website will be live at the same time and we can do like a twofer. But yeah, if there is someone you think would really enjoy it, you'll have a chance. Thank you, Ralph. Ed, did you have a question?
Yes. Could you tell me whether our Illinois history books, in particular high school books, cover this particular area? And if they don't, what does it take to get them to do this?
Well, I don't know. And I've talked to some high school teachers about my recent book, which has less about Illinois than I just described it. But what I've heard from high school teachers is that a lot of the history of the Northern struggle over civil rights in the antebellum period is not taught. So like, in other words, as part of your general curriculum, you might learn about abolitionists, you might learn about William Lloyd Garrison, you might have heard of Frederick Douglass, but you wouldn't know that there was this whole other thing going on in the North about a struggle for racial equality that gets kind of translated into, or some of the principles of it get translated into Reconstruction, which is what my book is primarily about, right? But in terms of Illinois history, I don't know. And actually, my kids went through public school in Evanston. My younger of two kids is now a sophomore at ETHS. And I don't think they got a lot of Illinois history at all. And I'm not trying to say anything bad about his teachers. He's had wonderful teachers, but so I've never seen any, actually, so I can speak only not in terms of it as teacher, but as a parent, I've not seen this material in schools, and I would love to talk about it. I really enjoy talking to teachers. I would love to talk about this. I would love to give you primary sources, like kind of try to develop curricular materials and things like that. So it's something I'm really interested in. Thank you for that question.
So that would be something you'd have to almost go to the state education board and like put an offer in and try to get to the right person. And, because textbooks aren't state by state, textbooks are more, the Scott.
But there may be, yeah, but in terms of Illinois history, it could go to the state, but also teachers are always bringing, adjusting curriculum and stuff like that. And it's the kind of thing that in a place like Evanston or Oak Park or Chicago or whatever, like you could have locally a decision that we're going to introduce some of these materials.
Districts, and stuff. That would be really great. Marianne has a question. She says, what do you know about the Underground Railroad running through Maywood?
I haven't come across anything about that at this time. So if you know something about it, I'd love to hear it. Or right now that's not something I know about.
Oh my gosh. All right, Janet Barkley.
All I wanted to say was I just thought you gave a remarkable presentation, and I'm so impressed by your research. Having been a librarian, it makes me appreciate it even more. And so your very enthusiastic and poised way of presenting, and with such conviction, just really impressed me. So thank you very much.
Thank you so much, Janet.
Janet. All right, Mike and or Judy.
Okay, I grew up in Alton, Illinois, and down where Lovejoy, of course, was martyred. And 2 points. We grew up being told that it was the citizens coming across from Missouri, across the river, that lynched him. I think I have since found out that's not true. Another point too, there was an old college there, and the legend is that part of that college was used as the Underground Railroad. Do you know anything about that?
I don't specifically know anything about the college, although I think I know what you're talking about there having been a college there. I'm not remembering the name right now. I learned so much about the history of Alton in doing the website, not mostly like the history of African Americans in Alton. early church organizing in Alton and Underground Railroad organizing. So Alton, especially before the rise of Chicago, Alton was one of the centers of Black population in Illinois, in part because it was right across the river from Missouri. And a lot of people moved into Alton from Missouri. And, you know, there were early Black Baptist churches there, some AME churches, there were Black private schools there. And so I am not at all surprised, you know, that they're about the Underground Railroad story. And, you know, as probably a lot of people here know, there are a lot of legends about the Underground Railroad, and then there also are facts about the Underground Railroad and networks of people who really did help people escape from slavery. So yeah, but I mean, we've been, as the project on the webpage has been tried to be very scrupulous about looking for contemporary sources that mention Underground Railroad activities as opposed to retrospective ones when lots and lots of people try to claim connections to it. But it's very plausible because Alton's right across from Missouri, and there were a lot of people trying to escape slavery in Missouri coming over into Illinois.
And someone certainly could have helped people without being part of the Underground Railroad. You know, it could be like a non-tied in thing. All right, we have time for one more question, and it's going to be Jean Louise Edwards. Jean Louise, you want to unmute yourself? Hi.
I think I did.
Hi.
Can you hear me?
Oh,
yes.
Okay, it just occurred to me, you know, critical race theory has been in the news. Well, at least I've seen it. Article written in the New Yorker magazine about it. And I was just wondering, is the material that you have presented relevant to critical race theory? I mean, is that the sort of thing that is being talked about being included in critical race theory? That those kinds of stories that we don't hear about ordinarily?
Well, I feel like this is a great question, a complicated question. Like, to my mind, what I'm talking about is American history. Is not critical race theory. This is history that, as you said, is like often the kind of history people don't already know that I think people should know. But I think the people who are, I would say that the critical race theory discourse is like a moral panic. Like, it's like all of a sudden all these people saying, oh my God, our kids are being taught critical race theory. A lot of times they're not sure what they mean by that. Mm-hmm. And I think sometimes they are, I don't know what they think, but I do think that some people who are talking like that have a problem with African-American history being taught, with the history of American racism being taught. And that's why some of the legislation that's being passed in Republican-led states right now is called like divisive concepts legislation and stuff like that. And they're saying things about how you can't teach things that are divisive, and you can't teach things that might make certain children, like white children, feel uncomfortable or feel embarrassed. And so I think the bad scenario is less about critical race theory, whatever, you know, however that is understood, and more that somebody would make the argument that teaching about something like the Illinois Black laws and the struggle against them would be divisive or would make white students feel bad. And I think that's, you know, absolutely not the case. I trust educators to know how to teach in age-appropriate ways. And I really strongly believe that this kind of history needs to be taught. And so, you know, I'm very concerned about, you know, not so much what I don't even fully understand, you know, not so much the idea of critical race theory, but I'm very concerned about what's going on in places where states are passing laws that kind of say no teaching divisive concepts, because I do think that history like this could be fit in there and could be, you know, taken out of public schools where it exists and not put in at all. And I'm very concerned about that. So thank you for that question. And I think, you know, it's a question that really speaks to the ways that in our very polarized context, you know, American history is often at the center of these discussions, particularly when thinking about young people. So I never felt more kind of like what we do as historians and history educators is more important than it is now. So anyway, thanks. Yeah.
And what a slippery slope saying you can't teach anything that's divisive, because then what do you decide next is divisive, and then it just keeps going. So that's very, very scary. Kate, I want to thank you so much for being flexible and moving online for this really great presentation. You again will let us know when we have that website. We can pass it on to everyone, and hopefully you all go. I know that Kate is so proud of what she's done and really wants people to use it. So we can all go on and help her populate it with our keystrokes and stuff. For the 19th Century Charitable Association, this is Erin Payton, and I just want to wish you all a wonderful Dr. Martin Luther King Jr. Day, and do something good today. Have a wonderful time. Bye-bye.
Thanks so much.